as bad as all of these women around you were treated by you, that when I pose that to you, reference your daughter, that's the best you could come.
Also reviewed the GPS tether report submitted, and there are no additions, corrections noted. We do have one request, however.
Hang on one second. You're talking a GPS. Is there a violation report?
It's not. It's copy.
I have a progress report.
I'm sorry, a progress report.
Okay, go ahead.
We do have a request though with respect to the tether. We're not standing here before the court asking that he not continue on the tether, but we're requesting that some addresses be added onto the travel path. He is co-parenting his 11-year-old daughter. The mother does not have her license. She actually appeared before this court, I believe, a few weeks ago. Tony Malone. I don't know if that name rings a bell or not, Your Honor.
No, it doesn't.
Okay. But the daughter is currently getting treatment at community mental health. Also at, she goes to, as a physician, she attends Tappan Middle School. There are prescriptions related to her treatment from Meyer Pharmacy. So I have the addresses, and we're asking that because Mr. Jones does have a license and he could pick up and transport his daughter to these appointments, get her prescriptions, that we're asking the court to add those addresses onto the travel path. It also includes the child's residence as well, and his place of employment at LA Fitness, Your Honor.
At where?
LA Fitness. And if the court would like, I can.
Whose place of employment?
Mr. Jones's place of employment.
When did that happen?
Your Honor, he's been it's more of a side job there. It's he's a boxing coach there. He does personal training there.
All right. Go ahead. I'll let you finish, and I'll tell you what I've got to say, because
that I've addressed the addresses. We would respectfully ask the court to add to the travel path with respect to the recommend.
Well, so that you know, I cut the travel path entirely out, and I did that because he shouldn't be on. Okay. Every time I get here with Mr. Jones, I get something new. And the last time that we were here, either last time or time before that, he had indicated that he had an apartment at the complex. He, in fact, gave us the date. Well, he didn't give us the date. He gave Community Corrections a date that he was moving in. It was also relayed to the court that the complex of where his daughter resided.
Correct.
And so in trying to carve out, I did something very unusual in that, because he is not supposed to be in Ann Arbor, Saline, or Pittsfield Township. So I carved out a specific roadway that he could travel, get to Pheasant Run, gave him Pheasant Run, and those were the only places within that he could be basically down Ellsworth Road. The reasons given for that was because that's where his daughter resided. Also, the reason was because he was going to be working in Canton. He was getting his employment transfer. Then find out, he reports to Community Corrections that he no longer has the apartment, which I wasn't clear on what happened there, but that he wasn't moving in.
And not to interrupt the court, I could address that when the court's ready as to why.
And then I just closed that whole way in and just told him he could not be in Ann Arbor, Saline, or Pittsfield Township. said nothing before ever about specific addresses, never said anything. That to me is as much a surprise as never again said anything about trying to get to one of the junior highs here or middle schools here. Nothing about that. And now that's the first time that I'm hearing it today, asking for a change in that. And LA Fitness is located where?
On Maple Road, Your Honor.
Yeah, that's where I thought. But he can't be on Maple Road.
Understood.
So when did that, and he knew Ann Arbor was out. So when did that come up?
Oh, it goes into the address first for his daughter, Your Honor, if I may.
Pardon?
With respect to the address for his daughter, he had the apartment ready to go. He was incarcerated for 8 days. There, Mr. Amadeo handled the bond hearing for Your Honor. He was released on tether. The apartment was no longer available to Mr. Jones once he was released. So that's why he's not residing there, but his daughter is residing there. I did receive, I'm sorry, Your Honor.
He deposited funds for the apartment. I mean, I don't know how that would occur. Because he specifically told us his move-in day.
He was supposed to sign paperwork, and I believe the paperwork that he was supposed to sign, he was still incarcerated, was not able to meet that deadline, and the apartment. Correct, Mr. Jones?
And he lost the deposit.
And he lost the deposit.
Go ahead. What about the LA Fitness? Because that was never even mentioned, and it isn't contained on as employment on his pre-sentence report.
You're right. He just did not bring that up to Mr. Odell about that. But with respect to the other addresses, respect to the daughter's physician, community mental health, I received communication from Miss Malone with these addresses. I spoke to Mr. Jones about this. He indicated she does not drive, and they have a 50-50 parenting schedule where he would have the daughter 1 week on, 1 week off. And because she doesn't have a license, he's primarily responsible for driving the child to her appointments, to school, to her extracurricular activities. And that's why I brought up to this court, the exceptions we would ask the court to make.
Ms. Valera, where did I have in my file a letter or something from Heather Moon?
Yeah, Your Honor, there was provided an updated victim statement.
Got it.
And I received that as well from
You have.
I have, and I've shared it with Mr. Jones, Your Honor. And Your Honor, with respect to the rest of the recommendation, there is no objection to the other terms and conditions of the recommendation. It's just these addresses that we're asking the court to grant him.
How many addresses are we talking?
May I approach, Your Honor?
Well,
These, I mean,
yeah, but I mean, how many are there?
We have 1, 2, 3, 4, 5 addresses, Your Honor.
That would be within the no-go-to zone.
They're in community mental health, which is on Ellsworth, South Grove Apartments, where the daughter resides, the Meyer Pharmacy on Carpenter Road, Pioneer High School, with the daughter has extracurricular activities, and Tappan Middle School, where she attends.
Not right now.
Not right now. She'll be starting in September.
Let's deal with the employment first.
Sure.
Do I have anything that indicates he's employed there, even part-time, side job, anything? Because that has not been reported to probation.
So he has nothing with him today, Your Honor. He's a 1099 worker. I would ask the court that we have a review hearing in September. I think perhaps that would be the ideal time. Perhaps he can bring that back to Your Honor to show.
But you're asking me for an exception to the exclusion zone.
Well, I'm asking for the exception for those, including the employment, but he doesn't have any proof of employment today. So if Your Honor, if he doesn't have anything today and the court wants to address the employment in September, we could do that, or he can provide that to probation. I'm sure tomorrow he can provide that to probation, a copy of the 1099 and anything else that he can get from LA to give to probation.
Is there a court order regarding parenting?
They do not have a court order, Your Honor. All I have is communication from Miss Malone. And Your Honor, I just became aware of this right when I walked in. I believe the daughter walked in prior to this case being called. I mean, she's here. I mean, I don't want to have an 11-year-old come up here, but I don't know how the court wants to, as far as any proof or verification.
Ms. Blair, you?
Your Honor, I just wanted to state, when I did the PSI with the July 1st, the only income for employment, I should say, that you mentioned to me, I reported, was that he worked for, which did the curbside pickup at Walmart and Sam's Clubs. Those were the only employment that all the indicated when I met with him on July. So there was no other Jim, he was talking about.
Your Honor, I didn't get a copy of any of these addresses. So the first I'm hearing about this on the record. So I haven't had a chance to do my due diligence and check things out either.
Yeah, okay, because.
And I apologize. I just received you.
No, I'm sure.
Problem that I'm having is that I'm really not clear what to believe with Mr. Jones. I'm just not. I mean, because frankly, during the course of the trial, I don't think he was telling the truth. When he came back up here, I don't think he was telling the truth. It's very clear to me that with certainly the women that were involved, he wasn't telling the truth. And now I get, we at one point have a picture of things that then changed to another picture of something. And now we come here and, you know, I get it, counsel, but I'm now with the third attorney.
Understood, Your Honor.
And I have now a different picture.
Understood. I guess the only thing I could offer is the one person that perhaps could verify it, Miss Malone, who's not here today, and with the court's permission, perhaps it was sentencing, and then I motion it up in front of the court and bring Miss Malone in, or Miss Malone could talk to Mr. Benak and communicate to the court. I'm just not sure I'm going to leave it to the court's discretion how to handle this, but all I do is I received a text message with a copy of addresses from Miss Malone indicating these are the addresses. This is what the daughter, where she attends her mental health treatment, physician, prescriptions, where she goes to school, where she has her extracurricular activities. That's all I have to offer to the court today, Your Honor.
Okay. Miss Bundy.
Thank you, Your Honor. Perhaps this time, as defense counsel suggested, people would also request that we move forward and make no changes to the tether today. Have faith in Ms. Pilar to communicate to the court if she's able to get sufficient documentation, and maybe things could be changed later.
I guess that's one way of proceeding. I mean, I guess
People also share the court's concerns because of the history of the case, the defendant's history before this court, and also it is the middle of July, so the concern about these school addresses being communicated. I understand that the defendant is being recommended for a 24-month term of probation, so eventually these children will be in school. but unless they're in summer school, they probably aren't right now.
Certainly the community mental health treatment is ongoing. I don't believe that's paused.
Okay. And again, with that, now I will say, at least with that, while it wasn't specifically stated, there was some indication of some type of treatment. But I don't even know. Nothing's been provided, I don't think. Ms. Flair, was anything provided to you regarding his transportation to for his daughter to community mental health?
No, Your Honor. Actually, I met with him. He was in custody, so, but he's not provided.
Your Honor, as prosecution noted, I will have, if the court would be satisfied, I would have Mr. Jones provide this information to probation.
All right. Very well.
With respect,
Go ahead.
with respect to that, we have reviewed the pre-sentence report, Your Honor. We would ask the court to adopt the recommendation. Fines and costs, my client's asking for 2 weeks to pay the fines and costs. And I don't know if you want to hear from my client at this time, or if you want to hear from, I know the victims submitted a victim impact statement. I don't know if they want to address the court, but my client would like to.
Wish to address the court directly.
Oh, written statement sufficient.
All right.
They are present, however, if this is a written statement.
With the court's permission, my client has prepared a statement on his own. He'd like to read it to the court.
I stand before you today with deep remorse and regret for my actions. I sincerely apologize to the victims for the stress and harm I caused by my actions and my bad choices. I understand that my actions were hurtful, inappropriate, and caused unnecessary anxiety. I take full responsibility for my behavior, recognize the effect it had on the victims and their families. My actions were inexcusable, and I'm committed to making amends and ensuring that such behavior is not repeated. I'm truly sorry for the pain and disruption I've caused, and ask for the opportunity to demonstrate my genuine regret and commitment to a positive change.
I'm rather amazed by you. The best I can put it. That's not necessarily a good amazement. I mean, the way that you just use women is just I mean, just incredible. And I know that maybe Mr. Sarapos doesn't know this or not, but during the course of the trial, we were dealing with Mills, and then out of that, what gave rise to all of that was you being out with some other woman after having been involved with Mrs. Mills for about 3 years. Then we come for a bond hearing, I do believe it was. An emergency bond hearing, which was prompted by this other woman that supposedly you had a 7-year relationship with. She's in court. Somehow, it was very clear from the expression on her face that she got lied to about who Miss Mills was, because she was absolutely shocked. You could tell from her face. And so it just is extraordinary to me that you would do this to all of these people. Not only, I think, as Ms. Mills put in her statement, they just hurting their hearts and their emotions, but then just doing all of these things to these women, promising whatever. I don't even understand it, quite frankly. But you do that. If you remember, I told you, I can't trust you. I just can't trust you to do anything, because when you were on the stand, you were lying about what was going on then. And what is so hurtful to me in a lot of ways is that you're raising a daughter. Mr. Jones, if somebody were to do what you've done to these women, to your daughter, what would your reaction be?
I don't know.
You don't?
No, sir. Your Honor, I don't know. I would feel regret.
What?
Feel regret for that.
Regret?
Yes, that, maybe not give my daughter insight on looking out for people like myself.
Just regret?
Hurt.
Man, talk like a father. How would you feel? You heard that about your daughter. Right? Talk like a father. How would you feel?
I would feel hurt and regret and anger. The best thing I can do is teach her to avoid what kind of man her father is.
If you're raising a daughter, why would you act that way?
It's mental health, Your Honor.
I'm going to tell you what, it bothers me also that as bad as all of these women around you were treated by you, that when I pose that to you, reference your daughter, that's the best you could come up with.
Your Honor, I seek mental health. I'm seek a therapist. There's a lot of things that I'm over my own opinions as far as my behavior to other people, and it's a mental health issue.
I was hoping for a minute when I asked you that question, sort of laid the background, that I'd get some answer that would make sense to this court. Because the cold-hearted reality of what I saw with this case, my initial thought was to impose additional jail time. I'll be absolutely honest with you. Because I don't know, because I heard the testimony, I know what you did to the Mills sisters, I'll just call them. I know what you did there. Left the other woman at the movies that they had to take your date home because you left them. And then I don't know, and I can't think of her name. I don't know what you told that poor woman that you were involved with for 7 years to get her to show up and even to write the letters that she wrote to this court.
Your Honor, I deal with mental health issues. I've had a victim of sexual assault when I was a kid, and I have a lot of trauma and stuff like that in my behavior. Destructive from that in relationships has been destructive in many relationships with people. I've failed to address it after getting out the Army, and having trouble with the VA. And I've actually been, from this point, I've been seeking mental health counseling. Deal with.
So where did that come from? And the only reason I'm asking that is because I'm looking at your pre-sentence report. He reports no self or family history of mental illness. You know what?
I don't know about anybody else in my family and their mental health issue. My family doesn't address mental health.
Okay, let's leave the family part out. What about self? You just sat there and seriously?
I left it out because I wasn't addressing it before my probation report. I haven't been addressing it, which is why my actions been the way they were. I have not been addressing my mental health for a long time. And that's why my action for the I'm about my mental.
You know what? You might stop. Because I'm going to tell you what, you can lie to all those women. That last person on this planet right now that you want to lie to is me. I'm looking at this report. I know that Miss Flair does a thorough job in terms of these reports. And you're sitting up here telling me something different. And I think you're telling me something different because somehow and or another, I'm supposed to, the light's not supposed to shine on all these women. You want me to shine it on you and feel sorry for you.
Talk to him. Talk to the judge.
Your Honor, I've been in denial about my mental health. All the way to being in jail. I've been in denial about my actions, stuff like and things like that. And when I was released, I was told by my sisters I need to go see mental health and address my issues, and it was a tough thing for me to do. I've been fighting it.
So where are you going now? If you are,
it was on 124 Pearl or Street. It's in Ypsilanti. It's the one of the mental health counseling that accept my insurance, and I have to do an intake and stuff like that.
So you haven't gone.
Your Honor, I filled out the paperwork and I have to turn it in, and I did, and I have to wait for them to intake. But I've made the efforts to do that, and I'm waiting for them to respond and when I can come in and my therapist will be.
Are you going to therapy? Are you gonna go?
So when did you go do that?
I did it online and filled out the paperwork. It was 9 pages, and I submitted it in. I contacted my IHA.
Where is it?
It's in Ypsilanti. It's 124 Pearl. It's a group. It's called. Can't remember right off the top of my head. I can look at my phone, but I don't want to. I know I can't do that. But it's a mental health counseling right in Ypsilanti. It takes Medicaid and.
Okay. Let's see if that's even the truth. Go get your phone, figure out what it is. Miss Polera, get a release so we can fax it over to him. I want to see if he even signed up for it. I'm going to pass them.
They have the documents. I don't have them.
They what?
They have the documents. I don't have the. I submitted them in online.
Okay. But we need to know where it is.
In 124 Pearl Street, integrative empowerment group. It's 124 Pearl Street, Ypsilanti, Michigan.
You got a phone number? Get it to Miss Polera. Don't give it to me. Get it to Miss Polera. Miss Polera, can you get a release from him signed so we can at least see if
online
he submitted the forms?
They told me they'll get with me when it goes through empowerment interrogate. Right. That's the I have to go.
So while we do that, so that these other people don't have to wait for this mass, I'm going to pass the mac.
Are you?
I'll submit. I'm not in yet. They have to review my paperwork, and then they'll get a hold of me. I don't know who does that.
I'm passing this matter. You can go back and sit down, Mr. Jones. Because right now, this recommendation in my head is changing. The record should reflect that we had a in-chambers conference on this case. And what I'm going to do is I'm going to adjourn the sentencing in this matter to August 5th. August 5th, 2024 at 1 p.m. Defendant and your counsel can explain that with you in detail. The other thing is that with reference to these addresses that were given, I'm going to need some verification or proof, and I explained that also to your counsel.
And that'll be emailed to Ms. Polaire as well, Your Honor, the
Yes.
verification. And Your Honor, if I heard you correctly, I believe you said enroll in and begin therapy. I think because of the tether may be problematic, but that maybe he brings in proof that he's enrolled.
Enrolled in it.
Yeah, okay.
And if it were to begin and there needed to be an exception to or an appointment.
This courtroom moment isn't loud. There's no dramatic outburst or instant sentencing. But make no mistake, this is where everything finally catches up to Mr. Jones. From the very start, the judge makes one thing clear. Trust is already hanging by a thread. Every time Mr. Jones comes before the court, there's a new version of reality. Addresses change. Employment changes. Parenting responsibilities suddenly expand. And now, at sentencing, mental health issues, surface issues that were never mentioned in the official pre-sentence report, that pattern is exactly what worries the court. The hearing begins with a request to modify GPS tether restrictions so Mr. Jones can transport his 11-year-old daughter to school, medical appointments, and activities. On paper, it sounds reasonable. But as the judge digs deeper, inconsistencies pile up. The apartment he claimed he was moving into? No longer available. The job at LA Fitness? Never reported to probation. Proof of employment? None. Even probation confirms this is the first time they're hearing about several of these claims. And then comes the turning point. The judge shifts the conversation away from addresses and paperwork and asks a simple, devastating question about Mr. Jones's daughter. How would he feel if someone treated her the way he treated the women in this case? That was the moment to show insight, empathy, moral clarity. Instead, the answer falls flat. It's vague, detached, more about abstract regret than real outrage. And you can feel the courtroom change. The judge isn't angry but deeply disappointed. Because for someone raising a daughter, that response matters. Under pressure, Mr. Jones pivots again. Now, it's childhood trauma. Now it's mental health struggles. Now it's therapy paperwork submitted online, but not yet verified. But the judge points out a critical issue. None of this matches the pre-sentence investigation report, where Mr. Jones denied any history of mental health issues. And that's when the judge draws a hard line. This courtroom is not the place for last-minute narratives meant to soften accountability. Mental health is taken seriously here, but that means verification, documentation, and consistency, not just words. Releases are requested. Proof is demanded. Because credibility matters more than explanations. Then comes the most sobering admission of all. The judge openly states that additional jail time crossed their mind. Let that sink in. Instead of moving forward immediately, the court does something far more telling. It pauses everything. Sentencing is adjourned. The recommendation is no longer secure. The record reflects that the court's confidence has shifted. August 5th isn't just another court date. It's a deadline. Between now and then, Mr. Jones has one chance to show that his actions match his words. Because when sentencing resumes, the court won't be listening for explanations anymore. It will be looking for proof. And that's the harsh truth of this ending. When credibility is gone, sympathy doesn't replace it. Only facts do.